Well, the suggestion that I'm making for my Lord's kind consideration is after division bench.
No, we'll not go into now. Yes, Mr. Majumdar.
My Lord, yes.
You have said that the petitioner has been considered. Their verification has been taken.
Yes, we are undergoing to
So
take
if
verification.
you are allowing them, what's the use of?
No, my lord, they whether they are to be considered for appointment or not on the basis of the orders, because the first sentence that I found in the writ petition was they are relying on judgments of the Honorable Supreme Court saying that this is the review order, this is the orders passed. Their writ petition starts with this sentence saying that the JV's judgment is not applicable to the state of Assam.
Huh?
That judgment, the original judgment, is not applicable to the state of Assam, is how they start their writ petition.
Who?
No, the answer
The
to
writ
that
petition.
is the writ
Yeah,
petitions were filed prior to the clarification order. When the judgment, original judgment came by which they disqualified me, the writ petitions were filed after that. Thereafter, during the pendency of these writ petitions, the Honorable Supreme Court on 10th December 24 has clarified that what my original order was not to devalidate or de-recognize the course. And after 10th December, 4 times, even 2 days back for state of West Bengal, they have passed a judgment, Honorable Supreme Court, where they have said that both these courses,
Then why don't you approach the Supreme Court?
well, the reason that is this. All those states, West Bengal, Bihar, Uttarakhand, etc., the high courts had given a judgment prior to the clarification and against us. Now, this is the only state, Manoj, in my humble submission, where the matter is sub judice when the clarification has come. So, therefore, all those states, which in fact, some of the states I had the opportunity to represent, we challenged the High Court's judgment holding against us, saying that they are misconstruing Honorable Supreme Court's order. So, therefore, the Honorable Supreme Court has set aside all of them, saying that West Bengal, Bihar, Uttarakhand, whichever went there, whatever the High Court has held was is erroneous, is what the Honorable Supreme Court says. And finally, what they have said is that both these groups, that is 24 months vis-a-vis 18 months, are at par with each other. In fact, here in Assam, we are at a better position because there is no appointment. Wherever there was
But
appointment,
wrongly or rightly,
Lord,
they have debarred you and they made you ineligible
indeed, Lord,
because of 18 months.
indeed.
Right, 18 months, right?
Yes, the state made.
So why don't you approach the Supreme Court?
The answer to that is this, Lords. Once they debarred me, they passed a circular on 2nd January 24, relying upon the Honorable Supreme Court's order. That circular is the subject matter of this writ petition, where I am seeking a quashing of that circular. During the pendency of that writ petition, the clarification has come. Now, for any reason, my lords, if my lord had to, of course, now there are 3 orders which they are bound to follow. It is an Honorable Supreme Court's order. If for any reason this writ petition is not allowed, saying that yes, the 2nd January circular,
See,
yes,
they have relied on the Supreme Court judgment.
subsequently it has been clarified, which they have not taken.
Then you approach the Supreme Court.
Plus, the answer to that is this. If it has been clarified subsequently for whichever there was a negative order, my lords, before the Honorable Supreme Court, and that is, if I can just show that for three states, I will take 1 more minute each. The problem is this, my lords. Now they are given a concession before the Honorable Division Bench, saying that I will be considered. If I will be considered, the 2nd January 24 notification, which is the subject matter of this petition, has to go, because that is the only hurdle. That's point number 1. They also gave a statement before the Honorable Division Bench that I'll be considered for the present 26th December 2023 advertisements. My second grievance in the writ petition also stands satisfied. So all that I'm seeking is that on the basis of those 2 statements given by them before the Honorable Division Bench, the writ petition may be allowed. That's point number 2. These are the 2 points. There is also a third point. The third point is this, that all these 4 judgments that have been passed by the Honorable Supreme Court in Bihar, Uttarakhand and West Bengal, laying down the same principle, they have extended the benefit of consideration only to the petitioners / appellants before the Honorable Supreme. So therefore, the third request that I'm placing for my lord's kind consideration is that the writ petitioners before my lords are about 1,700 in total. So the consideration by them for this recruitment of 26 December 2023 should be only restricted to these petitioners as laid down by the Honorable Supreme Court in those 3 matters. Now, for me to go there, my lords, I need a negative order. And any person approaching the court, my lord, would believe that we'll get a positive order before this court. Specifically, my lords, when those orders were passed there was no clarification. Hence, the Honorable High Courts in various states followed J.V. Singh and said that we are not eligible. But once we went there and we said that, yes, this is...
That's why you go again here.
My lords, by that time, can I just show that these 2 orders, maximum 1 minute, it will be completely clear. Can I just show those 2 orders?
I am clear.
My lord.
What I'm Why I'm not clear is why you are not approaching the
My lord, we don't have a reason to go there for now because the matter is sub judice before my lords, and my lord's kind indulgence on the last hearing.
Will grant you a liberty, close the matter, with
Can
the
I-
liberty to approach the Honorable Supreme
If my lord can
because-
just have,
Because the matter has been decided by the Honorable Supreme Court and it has been clarified. Why don't we approach this?
my lord would just have one order with me for a minute. In fact, my lord would just have an order of passed by this honorable court on 10th February 25. 10th February 25 in this batch of writ petition, there is an order passed. The order simpliciter says, I will not trouble my laws to go through it.
No, read it.
Yes. My lord, this order says, the petitioners, by way of instituting these batch of writ petitions, have raised the grievance with regard to the prescription of qualification in the advertisement dated so and so. The fundamental ground of the petitioners is that in terms of the determination made by the Honorable Apex Court in order dated 10/12/2024, passed in view petition so and so arising out of so and so, the petitioner's qualification of d.el.ed is being recognized. That is the grievance that is recorded. It is further contended by the learned counsel for petitioners, that is us, in terms of the aforesaid determination made by the Honorable Apex Court, the competent statutory authority NCT has also recognized such qualification which is acquired between 22/9/2017 to 31st March 2019. And accordingly, a notification has been issued. It is further the case of the petitioners that they have acquired their qualification during the aforesaid period and therefore their candidature should be considered by the selection committee. Mr. So-and-so, learner standing counsel for the education department, Assam submits that they may be allowed some time to respond to such contention. So therefore, and finally, these matters were to be listed on 18th March. So therefore, an IA was filed that now once the Honorable Supreme Court has given a blanket order saying that every state needs to comply with my clarification, why is the state of Assam not complying when state of Meghalaya has done it? All other states have done it. It is only state of Assam not doing it. So therefore, an IA was filed here. On that IA, this order is passed saying that once there is a clarification which is blanket, which is not specific to one state, you should please apply the clarification and the basis of which your circular was issued. So the circular of 2nd January 24, which is impugned, is only on the basis of Honorable Supreme Court's order. There is no other basis. So therefore, what was argued
According to you, that has been subsequently
clarified, and that has been
After
clarified.
the issuance of this.
Indeed. The advertisement is of December 20.
After the issuance, before the issuance of clarification,
My lord.
they have issued the impugned circular.
Indeed. My lord. Indeed. The impugned circular is prior.
They filed the affidavit.
They have not filed an affidavit, but my lord, with these three judgments, I would submit, and therefore I am taking this.
No, I've understood. We'll go at this. Without their affidavit, how can we dispose of the matter?
I understand. My lord, their concession is recorded.
I've heard you. We'll listen. We'll hear him.
Yes.
Whatever he said. Yes.
Lord, on the last order that was passed by lordships, I was required to be given the copies of the writ petition and all, not served to me as of today by that one.
I'm sorry.
Now,
We
with that
know, we have
affidavit,
fixed the
therefore,
matter. You have approached the division.
we approached
President
only,
Bench also fixed the matter.
only thing that we received, only thing that was there before the appellate court, the
No,
appellate,
forget about it.
no, there,
But
we
what is your response?
we only.
Okay, we'll give you a time to respond, file an affidavit, but then what do his response?
My lord, our
See,
response,
impugn order
they
has been
start-
issued. No, impugn order has been issued before the clarification issued by the
No.
Supreme Court.
the clarification, the first clarification came on 10th of December, if I'm not wrong.
Yes.
Our office memorandum was issued on January. So it was after the first clarification.
No.
It
January
started.
24. I'm sorry. January 24.
Just
is-
wait, we'll hear you.
That is what I remember the cases. Now, when they challenged that particular office memorandum, the first thing that they said was JV is not applicable to us. They start the writ petition saying JV is not applicable to us. The Supreme Court orders are not applicable to the state of Assam. So therefore, the office memorandum should go. Now there is a complete change saying that no, any clarification given in that case has to be applicable to us. What do I answer to me?
No. Actually, accordingly, you answered.
And now, my lord, now the
You say if it is not applicable, you said once you have said that it's not applicable. Matter ends there. Now we'll consider it. We'll determine it. Now they are saying that because after the subsequent, whatever
yes,
clarification, it applies. What do you say? on that.
The Supreme Court has clarified that 18 months d.el.ed course will be equivalent to the 2 years d.el.ed course. But still, in my humble submission, the state government has the right to find out which of the equivalent qualifications we need to choose for our selection.
No,
process.
nobody is objecting that you can, I mean.
So therefore,
you
we
can-
choose the 2 years, even then the 18 months goes. If we are choosing the 2 years, which is
No,
for our roots.
nobody is questioning your, the choosing whatever you choose, whatever
Yes.
your authority to decide
Yes.
what qualification, how,
True.
how much, what would be the qualification for a particular post. Why not on that? Today we're on that, after the judgment clarification of the Supreme Court,
My lord.
what would you say? Whether
We are
it
saying
applies
that-
to your state or not?
My lord,
If you, whether it applies to the state of Assam or not?
the judgments.
Yes,
If a certificate is equivalent, it is equivalent.
yes.
The Supreme Court says
So,
it is
you
equivalent.
cannot
it is
have a
equivalent.
debate. You cannot just
But
because
then-
no,
but
just,
then whether
just
we
because,
need-
just because you have the authority to decide
Yes.
what would be the qualification,
Yes.
you just cannot decide. Contrary to the what is
So that is why
passed by the court.
we would have to file our
have-
affidavit in the different cases, in all the cases, because there are two batches now I see. One batch which says that it applies, one batch says it does not apply. I do not have copies. I can start reading the first line.
No, let us not
Lord,
go
you will
into
find
that.
the
Let us not
first-
go into the technicalities of the pleadings. When-
The exact
It's a
reading,
reference, no.
reading is sacrosanct, my lord.
No, these are the only sacrosanct. I understand, but then the nature of the case where I mean dealing with, it's a simple matter. Why are you making it complicated? If you agree that on legally, when the Supreme Court decision is something different which cannot be made applicable in the state, you argue that.
That is what we would like to argue with our affidavit, my lord.
You just cannot have that kind of.
Lordship should give me a week's more time, asking them to give me the copy. We'll have it immediately on the reopening or we'll have it on Friday.
No.
I'll still try to
These
draft it up.
These are recruitment process
Oh,
just
it-
because that day you want to hear you argue the matter. I remember
Yes. And I had also made a
because you
statement
had
my
an
lord, that
apprehension that the process will be, I mean, staged.
stalled, yes. The process is not stalled.
Not
The
stalled.
process, the process. is
Now,
not-
when he made a mention this morning, I said, I'll not hear the matter. If it will take, I mean, detailed hearing,
My lord,
if that is your stand.
my lord.
But then he said, division bench is fixing the matter today.
No, division bench has said that the matter would remain fixed today. There is no
And,
difference in that.
the division bench interfered
Division
with
bench
the interim order just because of your own statement,
No,
saying
division,
that they are being considered.
we are, my lord,
They are
we are,
not
we are not, there was no statement made that.
Now,
because the
issue
topic will
in
find the order.
the office memorandum is in consonance of the decision of the Supreme Court or not. That is what.
May I just state, my lord, what was said to the honorable division bench? We said that since they have applied, all applicants who have applied under the advertisement, we are going for a physical verification of all of
That's
them.
fair enough. Fair
So
enough.
there, but as of now, the documents are being physically verified, there is no difficulty.
Yes.
But that is not the end to their problems or to our problems.
No, that's why if you are objecting, we'll hear you.
That
We
is what I was-
don't, since you have allowed them and you have, as the impression was made by
That-
the
that
learned
interim
counsel for the
So far
petitioner
as the
that,
interlocutory,
that since the petitioners have been
so
allowed.
far as the interlocutory applications are concerned, my lord, they are now set at rest because we have allowed them, we have called them for the, I'm sorry, we made a concession that we call them for their physical verification along with all other people. Any and everybody who has applied, who comes within that particular 1:2 or 1:5 zone, everybody comes to get their physical
Have
documents
you gone
verified.
to the judgment of Supreme Court,
Which one, my lord?
which is reliant?
Today morning, I was given a copy when I was in court number 4. I think I left it there itself. Yes, I left it there. I'm sorry, but there was a bunch of judgments which are
Decide it. Forget about what is there, whether you have correctly issued the impute notice or not.
my lord.
Impute this notification or not. Maybe state might have at point of time may not have looked into it. It's you to tell them. If you legally, if it is contrary, I mean, as per the, if you have issued it, I mean,
With
use
the
your
orders,
office.
with the orders
I would
passed.
request the Advocate General and you also to use your office, good office.
Could I pray, my lord, the matter be taken up in
Not
the
with the heck
immediately?
of- See, we don't expect. I mean, maybe there may be a wrong interpretation. Maybe to this court also.
I could be wrong also, my lord.
We do do the best of our
Yes.
knowledge only. So go for that. Let us not go into that whether once the state has issued an order, will have to defend it.
Not
There are
this.
cases which may not be, which may be
It may not be a
indefensible.
But
May
that
be
is,
indefensible.
but that
Then
is,
the way out is to advise the government.
would lordships.
And I understand, I had the experience. They always stick to their order, no matter how it is. They'll ask you to go to the Supreme Court also. If possible, International Court of Justice. If it lies. But then we'll have to
Because
advise them. I have not gone into, I have not but prima facie, I see that there is something
And-
contrary.
our first opinion which went in this case, when the first
And
time the matter came up,
Number
prior to Javid,
even
it
for a moment, I'm not saying that you don't have an authority to decide
was,
what qualification would be required for the particular. But problem here is not that. The issue. Issue is whether your notification debarring or
Needs a-
making them ineligible
needs a little.
is consonance with the decision or of the Supreme Court, or it is contrary. That's all.
But it-
You go to the Supreme Court judgment and declare petition thereafter, whatever is there, and then look into your office memorandum.
May I pray, my lord, the matter be taken up on immediately on the reopening on the first or second day, there is no difficulty. I'll have a consultation with the learned AG also. We'll try to have the department concerned. We'll have a discussion. Lordship will have it
This
immediately on the reopening.
Seriously,
by-
feel
because
that
by-
way the things can be resolved
Yes.
without having a kind of difficult adversarial form of litigation. We should resolve it.
This is,
See, tomorrow, if we find that this is something wrong, we're not here to confront with anybody.
no,
Where
never,
all of us,
never.
including you and us, we all are here for justice
Indeed.
to the best of our knowledge and ability. We're not against anybody.
We cannot. That is never, my lord, what-
The litigants before us is not only the petitioner. The government and the respondents are equally the litigant. So there cannot be any, I mean, kind of thing. that's-
the
In fact,
intention
when the
of the,
clarification order was given by the Honorable Supreme
So
Court,
in any case, Mr. I